So hello everybody. I invite you to take seat and I invite Judge João Renda to take seat for sharing the next session. Professor Hisashi Ikeda, Ikeda, please. And Professor Mero Batista, Mateus da Silva. Thank you again.
So, hello everyone, good afternoon. Minasan, konnichiwa. Ohisashiburi desu. Honjitsu wa Nihon kara okoshi itadakimashite makoto ni arigatou gozaimasu. Mata oai dekite totemo ureshii desu. I'm very happy and deeply honored to moderate this panel with Professor Omero and Ikeda Dai-sensei from Hokkaido Daigaku. And without further ado, I will give the floor to Professor Ikeda. Welcome, Hontoni yokoso arigatou gozaimasu.
And what about Yaba?
I should also say that
Yaba is also included in the presentation of Professor.
I should also say that Professor Ikeda is from Hokkaido Daigaku. It's a North Island in Japan, and it's a very cold place. And I really hope that Professor Ikeda is feeling warm here in Brazil. And I would really like to visit Hokkaido once. As some of you already know, I lived in Japan for 10 months, but I have never been to Hokkaido. It's a really wonderful place. And to our Japanese colleagues, I can also introduce Professor Omero as an acclaimed writer. And for young judges, we love Professor Omero's books.
Thank you, João.
And it's a kind of handbook in court that we always and we must have together so we can consult during the hearings, and it's a compulsory reading if you want to pass in a public selective process to become a judge here in Brazil. So I'm deeply honored to be with you too.
Very nice. Thank you. Very kind of you.
You're welcome. And when I went to Japan in 2017 for a lecture, it was interesting because there were some problems with the PowerPoint, but the Japanese sometimes are so strict in like planning and executing, and it was, I can say it was a little bit strange for me because like 10 people came to fix the PowerPoint, but it worked and it was a really an amazing experience. So Professor Ikeda, we kindly welcome you here again. Okay. You can use this microphone.
Thank you. Thank you, John. Hola. Meu nome é Hisashi Ikeda, muito prazer. Okay. Today, I'd like to introduce recent legal revisions on non-regular workers in Japan. As Professor Araki already introduced, poor legal protection on non-regular workers has been deemed as one of the major characteristics of the traditional Japanese employment system. So to speak, it is the V side of the Japanese employment system. Needless to say, Japan is a nation that has comprehensive labor protections. That is, even non-regular workers are protected by the minimum wage and overtime regulations, anti-discrimination laws, the right to organize, and all other labor protections, unless such regulations are limited to be applied to regular workers. However, it is surely recognized that the legal protection on non-regular workers has remained very lower level than that of regular employees. It is considered as an essential element to maintain the Japanese employment system. The Japanese employment system is a successful post-war model of employment system in Japan, developed after World War II. It is typically well known for its high level of employment security, in other words, strict restriction on dismissals for seishain workers, brought by the abuse of the right to dismiss theory that requires all dismissals to be both objectively reasonable and socially acceptable. Seishain is a de facto concept of regular workers in Japan and is considered as employees who satisfy at least three following requirements. First, working with permanent employment contracts. Second, having full-time jobs. And third, directly hired by employers. That is, employees who don't satisfy either of the three requirements are non-regular workers in Japan. Employees who don't work with permanent employment contracts are fixed-term contract workers. Employees who don't have full-time jobs are part-time workers. And most typical employees who aren't directly hired by employers are dispatched workers. Among these categories, fixed-term contract workers have been typically used as non-regular workers, and even today, most of non-regular workers are working with fixed-term contracts, even if they are part-time or dispatched workers. Theoretically, as Professor Araki introduced, a fixed-term employment contract terminates automatically upon expiration of the period specified therein. Since a termination is not a dismissal, the legal protection on dismissals is not applied. Accordingly, when reduction of the workforce is required, Japanese employers have turned to refusing renewal of fixed-term contracts, since dismissals of regular seishain workers are severely restricted. Thus, fixed-term contracts have functioned as shock absorbers to protect seishain regular workers against economic difficulties. However, after the collapse of the bubble economy in 1990s, the percentage of non-regular workers has been consistently increasing in Japan. The ratio of non-regular workers in the workforce increased almost double in the past 30 years, as Professor Araki introduced. And the ratio reached over 40% in 2015. There are various reasons that might cause such increase of the ratio of non-regular workers. Anyhow, one of the major motivations of employers to expand using non-regular workers must be the reduction of labor cost. As a result, even Japanese government became serious about the increase of non-regular workers, especially after the financial crisis caused by the bankruptcy of Lehman Brothers in 2008. In 2012, at the end of the former government under the Democratic Party of Japan, the cabinet passed the amendments of the workers' dispatching law and the labor contract law through the Diet to improve the working conditions of non-regular workers and to promote transfers from unstable employment to stable employment. As for the workers' dispatching law, this amendment has three main pillars. First is retightening the regulation on dispatching business. Second is improving the working conditions of dispatched workers. And third is strengthen the enforcement of the law. As for the first pillar, the most important revision was that hiring of very short-term dispatched workers, so-called hiyatoi haken workers, was prohibited in principle, because hiyatoi haken was deemed to be the symbol of unstable employment under the former recession in the last of 2000. As for the second pillar, for example, a dispatching business agency now shall try to take in measures to promote shifting their dispatched workers from fixed-term contracts to indefinite-term contracts. When a dispatching business agency determines the wages for dispatched workers, it shall consider balancing the wages of dispatched workers with those of the regular workers who engage in the same type of work in the same receiving company. As for the third pillar, the sanctions against illegal dispatch was strengthened. The receiving company now shall be deemed to have offered a direct employment contract to the dispatched worker when an illegally dispatched worker is accepted by the receiving company who is aware of such illegality. In such cases, if the dispatched worker declares his intention to accept such offer, an employment contract between the receiving company and the worker will be formed automatically. As for the amendment of the labor contract law in 2012, it was mainly consisted with three regulations as follows. First is Article 18. According to this rule, certain fixed-term employees are guaranteed the right to switch their contracts from definite to indefinite if the total period of their plural and successive fixed-term contracts becomes more than 5 years. Once a qualified fixed-term employee requests to convert his contract, the employer shall be deemed to have accepted the employee's request, and an indefinite-term employment contract shall come into effect. Second is Article 19. Unlike the other two regulations, it is just the codification of case law theory called Yatoidome Hori, originally set by the Supreme Court in 1974, the Toshiba Yanagicho factory case. According to this theory, the legal theory concerning dismissal of indefinite-term contract employees, abuse of the right to dismiss theory, shall be applied by analogy to refusing the renewal of fixed-term employment contracts when certain requirements are satisfied. Third is Article 20 of the Labor Contract Law in 2012. It prohibits unreasonable differences in working conditions between regular permanent employees and non-regular fixed-term employees. As for this rule, last year, the Supreme Court reached its first decisions in two cases on same day, involving interpretation of Article 20 of the Labor Contract Law. In those two decisions, the Supreme Court held that A. the Article 20 of the Labor Contract Law in 2012 prohibits unreasonable differences, taking into account the details of duties of the employees, the extent of change of such duties and work locations, and other circumstances, and it requires employees be treated in a reasonable and balanced manner according to differences in the details of duties. B. It rules that in determining the differences in wages between regular employees and non-regular employees are unreasonable or not, comparison of total wages between them is not sufficient, and respective purposes of wages and other allowances should be taken into consideration. As for rehiring after reaching mandatory retirement age, the court ruled that the reduction of wages, some allowances, and bonuses is not unreasonable, taking into consideration as other circumstances the fact that long-term employment is not expected and that the employees may be entitled to receive old age basic pension. And D. It also ruled that even if the difference in wages between regular employees and non-regular employees is unreasonable, the working conditions of non-regular employees will not be automatically made the same as those of regular employees by the operation of Article 20 of the Labor Contract Law. Instead, damages in tort will be awarded. These are amendments regarding non-regular employees under the former government of the Democratic Party of Japan. Soon after these revisions had passed the Diet, the Liberal Democratic Party won in the general election of the lower Diet in Japan, and LDP's long-term stable government restarted under coming back Prime Minister Shinzo Abe on December 2012. For the past over 6 years since then, current cabinet has tried to boost Japanese economy through unprecedented economic measures, so-called Abenomics. As the third arrow of Abenomics, a series of labor legislations has been enacted to change traditional Japanese employment system. On one hand, these reforms are aimed to change the traditional work style of regular employees, so-called seishain, by utilizing the area-limited or job-specified employment contract, promoting the role of elderly and women in the workplace, and setting strict restrictions on the overtime work. On the other hand, such reforms include introducing new regulations on non-regular workers. In 2014, the government passed a bill through the Diet that amends the part-time workers law. The main three regulations that are introduced by this amendment are as follows. First is the Article 8 provides for new principles that differences in working conditions between part-time non-regular worker and regular employees should not be unreasonable in light of the details of their duties, the scope and possibility of changes in their duties, the scope and possibility of relocation, and all other related elements. Second, according to the Article 9, employers are prohibited from discriminating certain part-time workers even if they are working with fixed-term contracts. Third, employers who have hired new part-time workers are now obliged to take certain measures for employment management of part-time workers and now obliged to explain to part-time workers such measures that they actually introduced and reasons of them, regardless of workers' requests. In 2015, LDP's government decided to amend the workers' dispatching law again. This amendment has three main aspects. First is that all dispatching business agencies now need to obtain permission from the government to dispatch workers. Second is that dispatching business agencies are now obliged to provide education, training and career consulting to their dispatched workers and obliged to take measures to aid dispatched workers achieve stable employment. And third is that the so-called 26 special job categories that had no restrictions on dispatching periods were abolished. Instead, this amendment introduced new dual restrictions on dispatching periods regardless of the job category. As a finishing touch of changing the traditional work style, Japanese government enacted so-called work style reform law in 2018. Under the work style reform law in 2018, the so-called equal work, equal pay principle will be introduced by integrating former Article 20 of the labor contract law into former Article 8 and 9 of the part-time workers law. As a result, former Article 20 of the labor contract law will be abolished, and the former part-time workers law will be renamed to the law on improvement in employment management of part-time workers and fixed-term workers. This revision will come into effect on April 1st, 2020 for big-sized companies and on April 1st, 2021 for small and medium-sized companies. Therefore, please be sure that this revision has not been in effect yet, and my following explanation is about future situation. Under Article 8 of the new part-time workers and fixed-term workers law, unreasonable difference in the treatment of fixed-term workers is prohibited as well as part-time workers in former Article 8 of the part-time workers law in 2014. Accordingly, it is generally said that the Supreme Court's interpretation of former Article 20 of the labor contract law that I mentioned before would be still valid as the interpretation of the Supreme Court and the new Article 8 of part-time workers and fixed-term workers law. According to the Article 9 of the new part-time workers and fixed-term workers law, not only part-time workers but also fixed-term workers who are deemed to be equivalent to regular workers are now covered by the prohibition of discriminatory treatment. As seen above, poor legal protection on non-regular workers has been one of the major characteristics under the traditional Japanese employment system. However, after the collapse of the bubble economy in 1990s, the percentage of non-regular workers has been consistently increasing in Japan. As a result, even Japanese government became serious about the increase of non-regular workers, especially after the financial crisis in 2008. In 2012, workers' dispatching law and labor contract law were amended to prevent increasing numbers and to improve working conditions of non-regular employees. Even after the change of the government on the end of 2012, part-time workers law was amended in 2014. Workers dispatching law was amended again in 2015. And finally, the work style reform law was enacted in 2018. It seems that such a trend to enact laws regarding non-regular workers would continue in conjunction with the reforms on the traditional Japanese employment system. Thank you for your attention. Obrigado.
My friend Hisashi Ikeda, Dai Sensei, thank you very much for your comprehensive lecture. And actually, it's a trending topic for all of us. And without further ado, I will give the floor to Professor Homero Batista.
Thank you, João. Congratulations on your Japanese and your English. I admire you. It's not very easy to go to Japan and study as you did in
2004.
2004,
Yeah.
before being a judge.
Yes.
Yes.
I used to be an undergraduate student.
Graduated student. Congratulations on your efforts. I was very impressed last year to realize that you studied there and then went to Rio to be a judge. You were at São João de Meriti last year,
Yes.
and now you are in Rio.
Yeah.
Yes. And now you are studying, but you are related to Rio. Professor Ikeda, it's an honor to be here with you. Professor Ikeda, I would like to congratulate you on your lecture. It is an honor to be here with you as well. Well, Professor Freitas asked me to talk about the non-standard the non-standard employee and new regulation in Brazil. But there is one thing I must say, especially to our friends from Japan. Brazil never suffers absence of law. We always have a regulation. This is something very true in criminal justice, in civil justice, in labor justice. We have a regulation enough. Someone told me that we have more than 100,000 laws, including laws and decrees. Maybe it's true. I have never counted it. Nobody has ever presented it, but maybe we have 120,000 laws, as someone had the opportunity to count. We have no problem about regulation. The thing is that we have no effectiveness. I told Professor Araki this morning that maybe Justiça do Trabalho, labor law court, is not the problem. The problem is if we have effectiveness in the sentences. This is something that law professors generally don't talk about. Maybe in social scientists or other professors may explain why Brazil has so many problems in enforce the law. This is one thing. So I'd like to start highlighting that we have undocumented workers. This is something that the regulation or no regulation is useless. When we were students, we learned that 50% of Brazilian labor market is undocumented. We say in Portuguese, informal, not formal. It's unbearable to have 120 million people in the economic activity and 50% undocumented and 50% documented. There is no way to develop it. The taxes are not collected. Professor Araki asked me about the taxes. They will not be collected because we have 50% aside. There will be no rules, no Justiça do Trabalho, no labor court for them. So they are the most important group to be studied. I would like to talk about the new regulations, mainly the zero-hour contract, about which Professor Freitas has talked in the beginning. But we must remember the undocumented. When I say undocumented, let me be clear. I'm not only talking about migration from Bolivia, from Venezuela, from Haiti, from Africa. We have these groups here. They are growing in number, but we also have the Brazilian undocumented people that don't have the papers to work or don't even have some papers to start the citizenship. Not only the people from Northeast, our poorest region in Brazil, but also from São Paulo, from Rio, that are simply undocumented. For us, it's very commonplace. It's very usual to have, oh, do you have, how many workers do you have in your enterprise, in your corporation? I have 100, 20 undocumented and 80 documented. This is unbearable. This is incredible. We couldn't talk in these terms, talking about how many undocumented and how many documented people we have. That's why labor justice and labor authorities are always accused of being so strict, of being so ruthless, because they look for the undocumented and try to enforce the law. Let's talk about the law, let's talk about society, but I think it's wrong to put the blame on those who try to enforce the law, as the judges or the authorities from the labor department. So we have been, Professor Ikeda, we have the fixed term contracts in Brazil for more than 70 years. Our first labor laws from 1953 also included the fixed term contracts. We have some types fixed term contracts for the worker to be tested, fixed term contracts for the in the agriculture or in the fields, fixed term contracts for the Christmas, so that when we have more shops and more money in Christmas time, fixed term contracts for Christmas, fixed term contracts for Easter time, fixed term contracts for vacation, for summer and for winter. We have lots of fixed term contracts, but they are in a better position than the undocumented people who don't even have the fixed term contracts. Part-time job. We used to have part-time job in Brazil only in the decisions of the judges. But since the financial crisis from 1998, that we call in Brazil the Russian crisis, we have the president of that time, Fernando Henrique. He prepared a package for the Russian financial crisis, and part-time job was included there. But we don't see part-time job generally. Very small amount of people in part-time jobs. 3 hours a day, 4 hours a day at most, because the law used to say 26 hours a week, and now until 30 hours a week. This is a good idea for small business, for some entrepreneurs, for a doctor or dentist that don't need a full-time job. But in Brazil, it's not effective. It's not popular. It's not common. People try to forget the part-time job and have the undocumented ones. Outsourcing in Brazil. We have been a soap opera, a long book telling about the outsourcing in Brazil. It's difficult to explain, but we used to have no law, and outsourcing used to be implemented in the day by day. And so the labor court decided to put some guidelines in the outsourcing. So we have been having outsourcing since the 70s, then in the 80s from security services. Then in the 90s, the Supreme Court, Labor Court, decided to put the guidelines, and outsourcing is widespread in Brazil. It's not very effective. They don't look for expertise. They look for a cheaper workforce. That won't work. So the big reform from 2017 decided to say that the outsourcing would be widespread, and the corporation decided whether they would have the outsourcing or not. Not the judges, not the labor department enforcement, but the corporation itself. This is the biggest news from 2007, but it is still an outsourcing considering the documented people. I'm not talking about the undocumented people again. So the most important the only new law we had in 2007, considering all the non-standard employment in Brazil, is the zero-hour contract. We used to have no parallel, no other zero-hour contract before 2017. Only 2 years. It's few time. It's impossible to measure the consequences and the developments. It's still too soon to make a balance or to make even a study about the zero-hour contract in Brazil. Enterprises, the corporations are very worried about it because the law is very confused. It's only one article with some guidelines, very few. The president decided to make a special decree explaining more details, from 5 details to 30 details. But this decree wouldn't be voted in Congress, so it came not into force. The thing very curious is that we have that 30 doubts. We don't understand if we have zero-hour contract in some business. We don't understand if they have night shift, must have the night payment. We don't understand if they can be protected by Social Security. So why not voting the 30 details? It was very strange that the same president that decided to enforce the zero-hour contract decided to keep silent about the details. So we don't understand exactly what zero-hour contract you have in Brazil. We have some beginning of zero-hour contract. Let me say in Portuguese, intermitente. That means it's not perfectly translated as zero-hour contract, but it means that some people that can be called by the corporation once or twice a month, a year. We don't understand exactly. There was an announcement in the big newspaper in Brazil last year calling people for zero-hour contract. The announcement said, we want people to work from 1 p.m. to 5 p.m. every Saturday and Sunday. This is not a zero-hour contract. And they called zero-hour contract a huge magazine and a McDonald's style of restaurants. 2 announcements, one from a shop, a department store, and the other announcement from the restaurants. I think the audience knows these announcements. One from Magazine Luiza, is a big department store, and the other from Burger King, the restaurants. This is not zero hour. They was trying to say a part-time job, maybe, if it is clear from 1 p.m. to 5 p.m. on Saturdays. But then it started like this, and I heard that the Minas Gerais Labor Court decided that it was wrong, but the Superior Labor Court decided it was right. So maybe we have no zero-hour contract in Brazil. We have some part-time contracts called zero-hour contract. Well, but the most important thing is the first one I said. We have never had problems in laws and decrees and writings and regulations. The problem is the enforcement, the effectiveness. We can't talk about regulation or non-standard employment without knowing this reality. Those who advocate for the zero-hour contract, who mock my preoccupations. They say that we have to make many efforts to bring the undocumented inside the system. That's true. I think everybody agrees with it. But now we have to remember the ILO decent work agenda. If it is to put these people in the system with some jobs, without minimum wage, with huge working hours, they are not treated in a decent way. So we have to be worried if we can put all the undocumented people in the legal system at any cost. This is not the ILO decent work agenda. This is my most astonishing word nowadays. If we can create these workplaces at any cost at all, even including the dignity of the workers. This is very astonishing in Brazil moment, in Brazil reality now. And to finish my small preoccupations here, I'd like to say to the Japanese friends that the reform from 2017 had not created as many workplaces as estimated. They sold the package as a 10 million workplaces provision forecast, and not we have not seen more than 500 places. These 0-hour contracts, they estimated in 4 million. 4 million 0-hour contracts is not as many as we would like, but even so, the 0-hour contracted was only 10% of this. So I'm afraid that we have already burned our our stockpiles, our ships, our bridges, and have not created the workplaces that we needed. This will be a very difficult task in the next generation or the next year, because we have already tried almost everything in the maybe not in a good way. So the new regulation on non-standard employment is something important, something that came into light in 2017, but maybe such a complicated way that we have not seen any kind of effectiveness. Thank you.
Thank you very much, Professor Romero. And I must say that the admiration is mutual and reciprocal, not only as a scholar and a professor, but also as a judge. And is there any question from the audience? Shitsumon wa gozaimasu ka? So I would like to make a question to Professor Hisashi Ikeda, Dai Sensei. And it's a curiosity and it's a trending topic, I think, worldwide. And I've been reading about Uber in Japan, Uber drivers, and so untensha no hito. And I would like to ask you, is Uber drivers, is it illegal in Japan? And because it's a trending topic for us, like work through digital platforms, and how to include these workers in a system of social protection. And for example, last week in California, they passed a bill, the Assembly Bill number 5, considering Uber drivers as employees for minimum wages purposes and overtime pay purposes. But I think that Uber in Japan is a kind of illegal. Is it true? And is there any special protection for taxi drivers? And because I think you have apps only to call taxi drivers, but I think on the other hand, I think that, for example, Uber Eats, like to delivery food, it's popular in Japan. And how would you consider a worker that works through Uber Eats, for example, or through Uber, an Uber driver? and I'm really curious about that. How is it working right now in Japan?
Okay. Yeah, it's okay. First of all, I think Uber is prohibited in Japan for now because not labor regulation but traffic regulation prohibits it. So there is no Uber services in Japan for now. But as you mentioned, Uber Eats, uh, we can use Uber Eats in Tokyo or other major cities. So uh, as for the workers who are working as a driver of Uber Eats, uh, generally speaking, mm, we think such drivers are not employees under labor standards law or labor contract law, but we generally think such drivers are still workers under uh, uh, under trade union law. So we think them they can make uh, organize trade union, and they can uh, bargain collectively so to improve their working conditions. So that is the current situation as a yeah, generally speaking.
Thank you very much. Okay.
Nobody has any questions here? I have a question, if I may, if I may talk with Professor Ikeda. Uh, when I was in Japan, Professor Araki showed me that as we have in Brazil, employee never sue the employer during the labor contract because they are afraid of unemployment. Of course, in Brazil, the turnover is very high, in Japan is smaller, but in both countries, the workers never sue the employer during the contract. But in Brazil, we have had a new system since 1966, which is called Fundo de Garantia. Is a system that improves the turnover. And so since 1966, it's very common to sue the employer as soon as you are fired. And I realized that in Japan, when you had the fixed term contract, now I think it's 1/3 of the workforce is in fixed term contracts, isn't it? 30-80%. It's directly linked the number of the process in the courts as the number of the fixed term contracts grows, so the number of process also grow. Is it right, this kind of thought that I had? Because in Brazil it's very similar what happened. The statistics showed me something, inspired me to ask you about it, because I think from 2006 and when the fixed term started, so the number of the processes started to grow as well. Have you ever realized it?
You mean as a number of
Litigation.
employment employees increases, litigation numbers
Yes.
of
Yes, because the workers feel free to sue the employer when they are unemployed. It's not so simple to make this affirmation.
Actually, I'm not sure that, but
in Brazil, it's 98% of the litigations are unemployment, because it is very difficult to sue the employer during the contract.
so you mean fixed-term contract employees easily
Yes.
unemployed, so
After the
they
contract.
can sue their ex-employer
Yes.
very easy.
Yes. You are not so sure about it. I thought it was more clear there.
It's interesting, but I'm sorry, but I'm not sure for that question for now.
Because in Brazil, before 1966, we used to have long time contract. The turnover was low, and we have this kind of stability in the workplace. So you usually wouldn't sue the employer when you were in the workplace. That's what changed in Brazil since the 60s.
Theoretically speaking, fixed-term contract employees can file suit easily after their contract expired. But in Japan, I have never heard that the number of suit filed by fixed-term employees increased after the collapse of the bubble economy. So
Let's check.
Yeah, thank you. Okay,
Let's check
it's
together.
very interesting. Yeah,
thank you.
thank you.
And to a foreign observer, I should say that in Japan they don't sue during the employment relationship, and they don't sue afterwards
After
either.
as well.
But I was really impressed because I went to watch Rodo Shinpan, this special proceeding on labor and employment law. Once Professor Shimamura took me to watch a hearing, and I think we are going like on the opposite way, because the Japanese civil procedure is adopting some specific labor and employment law procedures. And here there is a strong debate about abolishing labor courts and abolishing labor and employment procedure. And I really think that we are going on the opposite ways. And besides, we are a country of massive litigation, and Japan is considered a country of with lower rates of litigation. I think we are going on the opposite way. Is there any other question from the audience, or from my colleagues here? So I would like to thank you very much. It was an honor to moderate this panel, and we will have a short 15-minute break, and we will be back very soon with the next panel. Thank you very much.
Hello again. Professor Maria Emilia and Professor Jorge Bolsinhas couldn't be here in this afternoon, so I am pleased to be the chairman of the session 5, and Professor João could will help us with some special presentation later on. Let's start with Professor Konishi. Sure. Okay. Well, we are in this session 5 in the area of working hours and overtime work. Professor Konishi will show us an overview about this subject in Japan, and I would like only to say one or two words about the overtime and working hours in Brazil. Only one or two words. It's not a presentation, it's just to communicate with my Japanese friends what is happening nowadays in Brazil. We have, Professor Araki, the 44 hours pattern in the week, a 44-hour week. This is our constitution from 1988. But don't ask me about the effectiveness of it because many people work 50 or 60 hours a week. 44 in the constitution. Then we have some problems about how to spread these 44 hours in the week. For instance, can I work 12 hours a day? We shouldn't work 12 hours or 14 or 13 hours a day. 80 hours a day would be the most expected pattern in the day. But in Brazil, it's not rare that someone works 10 hours or 12 hours a day in a kind of a compensation times. But this is very stressful, and we have some studies that show that health and security is not very protected because 12 hours is very dangerous for those who work in high noises, with radiation, with humidity, with the agents, the chemical agents. The reforms, the labor reforms, emphasize that the employer can spread however he wants, with 11 hours, 10 hours, 12 hours. This is not a suitable model. So in Brazil, again, as I was telling in the regulation of non-standard, the problem is not the law. We have reasonable laws. 44 hours is not an unreasonable law. 8 hours a day is not a reasonable law. But the reality is more complicated than the law. So it's just to present you that we have working hours, decent working hours in Brazil, but overtime work is widespread. And finally, before Professor Konishi starts, I'd like to only to share you my pleasure to have to finish a research here last year, a 5-year research with my one student from Franca, from interior, from the state of São Paulo, trying to prove that overtime kills. We read more than 10 years of documents from the Social Security at what time exactly, precisely, the worker died, considering the labor day. If he died in the first hour, or he died in the second hour, or the third hour of that special day. Because in Brazil, we used to have a document where the employer should fill in the blank and what time, not only the clock time, but also the working time. And we could prove that workers generally die in the 9th hour. This is the peak of the accidents in Brazil. Not the 7th, not the 8th, but the 9th hour. The 9th hour, which is forbidden, generally. 8 hours is the pattern. So the name of the thesis of my student was The Accident Hour. It's an ambiguous title to emphasize that there is an accident hour. There is an hour that the accident is very probable to happen. The 9th hour, at least in our experience in Brazil. The statistic is very easy to see. The accidents and the 9th hour, then the 10th and the 11th. So for us, it was a way to highlight the importance of at least trying to um, uh, not to make more emphasis in overtime to try to have less overtime in Brazil. But this is a social problem and an economical problem, not only a labor problem. So that's why working hours and overtime work for me is a very special preoccupation. Professor Konish, I am very pleased to present you, and I would like to invite you to make this presentation. Thank you. How would you like maybe here? Yes. Not yet. Let me try.
Ok. Obrigado muito, professor Romero. Boa tarde, muito prazer conhecê-los. Estou muito feliz pela oportunidade de estar aqui no Brasil, poder encontrar algumas pessoas e conhecer novas pessoas. Obrigado.
Thank you. Where have you learned so well Portuguese? In Meiji University, they have this kind of Portuguese classes. Thank you, Professor.
Thank you. Today, I will talk to you about working hours and overtime in Japan. First, I will talk about the profile of working hours in Japan. We will see some data concerning working hours. Then I will talk about how working hours are regulated in Japan. And in this chapter, I will talk mainly about overtime regulations and exemptions. These two fields were amended by Work Style Reform Law in 2018. And this bar graph is about the ratio of male regular or standard staffs working 60 hours and more per week by age group. This indicates that about 20%, in other words, about 1/5 of male regular staff aged from 25 to 39 worked 6 hours and over per week. And related to the working hours in Japan, I would like to show you the data of karoshi or karojisatsu in Japan. First, I would like to give you a definition of the word karoshi and karojisatsu. Karoshi means death due to overwork, mainly caused by brain or heart disease. Whilst karojisatsu means suicide due to mental disorder triggered by psychological burdens at work. And these are graphs about the number of cases in which a workers' compensation insurance benefit was decided to be paid. As the upper graph indicates the number of cases of industrial compensation insurance for cerebral or heart diseases, most of which are caused by long hours of work. And the blue line indicates total cases of industrial compensation insurance for cerebral or heart diseases, while a green line indicates cases of death due to cerebral or heart diseases. The lower graphs indicates the number of cases of industrial compensation insurance for mental disorder. A green line indicates cases of death due to suicide rooted from mental disorder in Japan. From here, I would like to talk about working hours regulation in Japan. First, let's see basic principle in Japan. As to the maximum working hours, weekly maximum is 40 hours per week, and daily maximum is 8 hours per day. Concerning with rest period, an employer must allow at least 45 minutes of rest period for more than 6 hours of work, and at least 1 hour for more than 8 hours of work. With regard to rest day, the Labor Standards Act stipulates that at least 1 day of rest day per week must be provided to employees. These are the principles of working hours, rest period, and rest day. However, there arise needs for employers to have their employees work beyond the maximum limit of working hours, 8 hours, or to work on rest day. In order to respond to such demands, the Labor Standards Act provides two exceptions to the principles of maximum working hours and rest day. The first exception is overtime work in case of emergency. However, this exception is rarely used because it is much easier for employers to fulfill the requirement of second or another exception. The second exception is overtime work ordered on the conclusion of a labor management agreement in accordance with Article 36 of Labor Standards Act. A labor management agreement is a written agreement between the employer and the representative of employees in the establishment. Before in Japan, the Labor Standards Act had not set no limitation on the amount of overtime. The 1998 Labor Standards Act revision set the limitation of overtime and gave it a more solid ground by ministry ordinance concerning standards on overtime limitation. Please see this slide. This is the normal hour regulations, and over this limit there was an exceptional working hour regulations, and the Ministry of Ordinance set this upper limit. set this upper limit of this exceptional working hour regulations. But there was another exception. This chart shows before in Japan, in exceptional and unavoidable cases, labor management agreement could set the limit of overtime hours over this overtime limitation by this ordinance, and employer could not be penalized as long as labor management agreement was set and employee worked within the limit set by labor management agreement. So I could say that till this March 2019, as this chart shows, there could be no absolute or legal limits. The new work style reform regulation was passed in 2018 and makes significant revisions to Japan's labor laws, including Labor Standards Act. Under this law, the Labor Standards Act set express and mandatory maximum limits to overtime hours, except in exemption cases, which I talk later. The new rules set two types of limits. The first is the basic rule. This one. This one is as for this basic limit, overwork hours, which are working hours exceeding 8 hours per day or 40 hours per week, cannot exceed 45 hours per month and 360 hours per year. The second rule or second limit is this one. This limit could be called as extended limit. When there were special circumstances, the employer is allowed to extend the basic limit. However, the total number of overtime work and work on rest days cannot exceed 100 hours per month, and the average overtime hours cannot exceed 80 hours per month on average for some period. And the number of months when the employee works over the basic limit cannot exceed 6 months in a year. Moreover, the yearly maximum extended limit hours for overtime work is 720 hours. And as to this criteria of extended limit line is set by reference to the criteria of the certification of death after long time work, as I mentioned, as industrial compensations. This slide shows a premium to employees. If an employer had employees work overtime or on rest day, the employer is required to pay overtime premiums to the employees in addition to the normal wages. Additional wage for overtime work is at least 25% of the employee's normal wage. Additional wage for rest day work is at least 35% of the employees' normal wage. And in addition to these regulations, as a new measure to secure employees' rest and help them strike a life-work balance, the work style reform law urges employers to make efforts to ensure that a certain interval, 11 hours between the end of working hours for one day and the beginning of working hours for the next day. So I could say that this regulation indicates that this reform will put weight on not only a working hour, but also not working hour. And from here, I would like to explain about the exemption system in Japan. There are three types of exemption in Japan. This is a first type of exemption system in Japan called discretionary work scheme. Labor Standard Act introduces a conclusive presumption system called discretionary work system. This scheme allows an employer to calculate the number of work hours based on the conclusive presumption of hours worked that were agreed on between the employer and the representative of workers, regardless of hours actually worked. For example, the conclusively presumed hours to be 8 hours. The employer can regard a worker's working hours as 8 hours, even if the worker actually worked 10 hours. Since this system is involved with calculation of working hours in Labor Standards Act, I could say that this system is the exemption system just about working hours, not night hours, etc. And there are two types of discretionary work scheme. The one is a professional work type, and the other is management planning type. So because of time constraints, I cannot explain each type in detail. So I will explain those in a concise way. As for professional work type, which is available in limited duties, for example, designing, copywriting, lawyering, etc. And to introduce this system, to introduce this system, a labor management agreement is required. And according to the data, this system is introduced in 1.3% of all establishments in Japan. The second type, management planning type, which is available for duties of planning, investigation, and analysis of matters regarding management of the enterprises. And it is necessary that the nature of the work is such that the means of carrying out said work for its proper completion need to be left largely to the discretion of the workers. And to introduce this system, Labor Management Committee must determine duties and workers covered by this scheme, and employers must obtain the consent of said workers. According to the data, this system is introduced in just or only 0.3% of all establishments. Therefore, in Japan, it has been discussed that the scope of this exemption system should be enlarged to deregulate working hours regulations. And the second type of exemption system is persons in positions of supervision or management. Some categories of employees, such as managerial employees, can be exempted from working hour, rest day, and rest period regulations. However, the scope of this exemption is narrow and limited. For example, with regard to white-collar workers, only those in upper managerial position can be exempted. Moreover, this criteria is not so clear in concrete cases. And this is, in addition to these two types of exemptions, the third type of exemption was introduced by work style reform laws in 2018. Under this work style reform, the government expands the scope of the exemption of white-collar workers by creating a new category of exempt workers. And this rule is available to those engaged in job requiring highly professional skills or knowledge and earning yearly wage of 10.75 million yen or 102,000 US dollars or more. To introduce this system, as you can see, there is so many requirements, and because of time constraints, I can't explain in detail, but I would like to point out that the interesting features or point of this system is that the idea of no working hours is inserted in this system. For example, sure, 40 days or not less than 104 days, or a work interval system, or setting the upper limit. So this system put away on non-working hours. And as for the effectiveness of this system, the introduction of this system allows exemption from not only working hours, rest day, and rest period regulations, but also night work regulations, while above-mentioned second type category, persons in positions of supervision or management system, it does exempt night work regulations. But according to the news media information, the number of actually applied workers for the first month after the entry of this system in April 2019 is just one case in Japan. Just one case, yes. So this fact might indicate that the new exemption system is so complicated or so rigid that companies don't want to use this system. This is a chart which simply indicates working hours regulations and so forth, and the amendment set by a Work Style Reform Act. The blue part shows that with Work Style Reform Act, the absolute upper limit of working hours is set. The yellow part is involved with the content of exemption for high-level professionals introduced by Work Style Reform Act. Lastly, I would like to summarize today's presentation briefly. The first, by work style reform law, the absolute upper limit of overtime and the new type of exemption are set. The second, in addition to working time, ensuring non-working time has more importance than before. The third, and finally, I could say that with this reform, the connection between working hour regulation policy and workers' health policy become more tightened. Thank you very much, and obrigado muito.
Professor Konishi, may I ask you a question? Someone told me when we went to Japan that this high-level professional, they put $102,000 a year to be considered high-level professional. This amount is the amount that a clerk in the bank earns. They said that this was directly put to exempt the banks, so that in the banks, financial institution, banks, they will never pay overtime anymore because this is the wage of the average bankers, average employees in a bank. Did you understand my question? No. How did they choose this 10 million yen? Because 10 million yen is not the wage of a high-level employee. You are going to be called the high-level professional with the 10 million yen wage per year, yes? But 10 million is not a wage for a high executive. Is a wage for a bank manager, isn't it? Because in Brazil we have this problem as well, but we don't have a fixed amount. We say that they are a high-level manager, but we don't fix the exact amount of the wage. And there in Japan they put 10 million yens.
Yes.
10 million yens is a high wage or a medium wage?
Yes. Yeah, so I'm not sure exactly, but according to some data, the workers who earn over 10 million yen yearly is about 3% in Japan.
6%.
3%.
3% of the workers. So it's a high wage.
Yeah.
Okay. Someone told me that the law was going to put a medium wage so that many corporations would be exempted. That I was afraid of it. So only 3% earn this 10 million.
Yeah.
Okay. In Brazil, we don't have the amount. We only say that he must have a wage bigger than 40% bigger than his team. So it's a little confusing for us. Thank you, Professor. Well, as I told you, Professor Maria Emilia is not here, so Professor João was very kind to accept the invitation to make a special presentation for us this afternoon. It's not an overtime presentation, but since he is now studying in Boston, in Harvard, he is going to show us some details about American legal system. So would you like to change with Professor? Yes? To show us your special presentation. May I help? Sit there, just there. João lived 10 months in Japan and 10 months in Boston. Yeah. You have been there for the last 10 months, yes?
Yes, since January.
Since January.
Can I just use this one?
This one?
Yes. Thank you very much, Professor Romero. Thank you very much, Professor Konishi. I'm deeply honored to kind of replace Professor Emilia. And my sincere apologies because I will present, and the slides are in Portuguese. Actually, it's a lecture that I provided last month, but I will try to translate into English, and I will try to explain to you what I'm going to talk about. And first of all, I'm honored to share the table with Professor Konishi. And as I mentioned, I lived in Japan from 2004 to 2005. I used to be 19 that time, and I was an undergraduate student. And if I can, I really want to go. It's a kind of advertisement of Meiji University, because Meiji University has an amazing Japanese law course for foreigners during the summer. And if I have the opportunity once, I really want to study in Meiji Daigaku, which is an amazing university and an amazing place to study and to do some research. I'm a labor judge in Rio Regional Labor Court, and I'm on leave from court to carry out a research project at Harvard Law School, and I'm writing a thesis on comparative labor and employment law because I saw that the most important reports of our labor reform bill in the House of Representatives and in the Federal Senate quoted the United States about 30 times and the word freedom about 20 times. So the United States and freedom maybe are the expressions that are repeated most times in our labor reform bill reports in the House and also in the Federal Senate. So I became curious to know a little bit more about the American legal system and about labor and employment dispute resolution in the US. Because there are some, I can say there are some myths on American labor and employment law that are kind of repeated many times here, and they are kind of, I can say, like fairy tales or fallacies that are constantly repeated here. And there are some out of context views, and even some American Supreme Court cases have been quoted by the Brazilian Supreme Court, but somehow out of context. And actually, we cannot talk about an American legal system because there are so many legal systems in the US. Labor and employment law is completely different. For example, in California, which is considered a pro-labor state, and in Alabama or in Georgia, Massachusetts, where I'm living, is also considered a pro-labor state. And some states are called right of work states, and there is a right of work movement. What is that? These are states, right of work states are states where agency fees, compulsory agency fees, for us in Portuguese, contribuição assistencial, they are allowed if there is express stipulation on collective bargaining agreements. They are allowed in about half of the American states. And when the Brazilian Supreme Court decided about our union tax, I could say that we had a union tax because it was compulsory and it was a check-off system deducted from the employee's paycheck every month of March. Our Supreme Court justices discussed the Janus case of the American Supreme Court, but they didn't understand. And some cases like Epic Systems versus Lewis about arbitration agreements with class action waivers are also very important for us, and many people wrote about these cases, but sometimes it's hard for us to understand because their system and their systems, I can say in the plural, is very different from ours. And talking very shortly about legal education, our systems are completely different. We are a civil law country. Besides having many points of contact, and the systems are approaching to each other, the civil law and the common law, but we still a civil law system, and we follow Roman Germanic tradition. And if you go through the aisles of the University of São Paulo law schools, maybe you are going to see undergraduate students carrying what we call vademecum. It's a compilation of codes, of statutes. And if you go through the aisles of Harvard Law School, you will see the students carrying case law books. It's case law. If I ask someone about the statute of limitation for a case, maybe they will answer reporting to a specific case that they can find in case books, and they follow a Socratic method and a case study method. And I can say we follow a kind of European method where the professors like to provide lectures, and very long lectures, and sometimes it's not so much like participative. The students don't participate so actively in classroom. And this is the CLT organized. It's not Professor Homero's CLT, but if you go through the aisles, you may see many students carrying the Professor Homero's CLT commentated, like a compilation of statutes, and sometimes statutes commentated. And so there are some myths about American labor and employment law. This is just a post of an owner of a retail store, a huge chain of department stores, and he was talking about American labor and employment law as an example to be followed, because it should be, from his point of view, it's a kind of simpler system. But I'm at Harvard Law School since January, and I can say that it's very hard, and for employees, it's very hard in the US, for example, to have legal counsels and lawyers, because from one state to the other, the labor and employment dispute resolution system is completely different. They have so many overlapping regimes. It's so hard to understand. Even the Massachusetts labor and employment resolution system is so hard to understand. But I'm trying, I'm doing my best in my research. And like, to understand these differences, it's important to try to explain a little bit of the histories of our countries. Because the US, they are considered a federation per aggregation, because in the past there were 13 English colonies that became independent, and they gathered and they decided to have a central government for military purposes and for commerce purposes. And in Brazil, we had the opposite. We were a united country which belonged to Portugal, to the Portuguese crown. And from a united country, actually the Prince of Portugal proclaimed the Brazilian independence and proclaimed himself as the Emperor of Brazil in the past. But when the Republic was proclaimed, we decided to share some legislative initiatives and to delegate some power to the states. But actually in Brazil, the central government has the exclusive legislative initiative to pass bills on labor and employment law. It's in our constitution, in Article 22 of our constitution. And I have been a judge in the countryside, in the interior part of Goiás state in 2013 and 2014. It was a rural experience, a lot of rural work. And then I went to Rio de Janeiro Regional Labor Court, a completely different reality of urban work. And I still applying the same labor and employment law. Labor and employment law is basically the same, for example, in Rio or in São Paulo and in the Amazon forest, the worldwide famous forest, because only the National Congress and the central government can pass bills on labor and employment law, and this is a strong difference compared to the American system, because and it reflects in our labor and employment resolution systems. We have federal courts which specialize in labor and employment issues. In the US, I'm just quoting, for example, the Kentucky statute. It's a state statute saying that it's unlawful for an employer to discriminate on the basis of like being a smoker or non-smoker. If an employee, for example, is a smoker, the employer cannot deduct health insurance plans contributions in a higher percentage compared if he's a non-smoker. And so the state legislation is very different from one state to the other. And talking about our what we call here collective labor law and what they call only labor law, the union system is completely different, and they have a system in which they try to preserve the free choice. But preserving the free choice is a kind of utopic, because to protect free choice, at the same time, they have an official system of labor dispute resolution, and they have what they call unfair labor practices that we would call condutas antissindicais here in Brazil. And the National Labor Relations Board is the federal agency which specializes in the resolution of this kind of issues. And when, for example, a union starts an organizing drive, an organizing campaign, it's a very complex situation for the employers there. And if this guy is in the US, and if there is an organizing drive, and sometimes there are more than one organizing drives taking place at the same time, sometimes it's very hard, and the employers, they start what they call vote no campaigns, and many cases go to the board, and the board works as a compulsory, what we would call an administrative compulsory jurisdiction. It must go to the board. Here, it would go to the judiciary branch. There, it's a specific institution specialized in labor dispute resolution between unions and employers. So sometimes when people say, oh, the US don't have labor courts and don't have institutions specialized in labor and employment issues, actually it's not true, because they have, and the decisions provided by the National Labor Relations Board, they can be appealed directly to the Court of Appeal, to the Federal Court of Appeal. And so there are many cases also from the American Supreme Court on labor and employment issues. These are only union authorization cards. Sometimes when they have massive support, there is voluntary recognition of a union. Union rates are declining in the US, but sometimes here, when we talk about American labor law, it's very hard to understand, because the system is really different from ours, where we have a kind of forced system of unionization and a single union in each territorial basis. And they have this kind of elections in a secret ballot. And this is an official secret ballot, and the employee votes yes or no. But there are many problems regarding freedom of speech, regarding campaigns, vote yes, vote no campaigns. And sometimes it's really complex to understand. I need to be fast because I don't have so much time. This is the National Labor Relations Board, the regional office in Boston that I visited last month. And I audited a hearing in a representational case. It was there was an organizing drive, a union's organizing drive in Macy's, which is a huge department store, and there were some problems regarding the elections, and they went to the board to decide this case. This is a hearing room. I took the pictures when people had already left, but this is an ordinary hearing room. And I'm just showing this because sometimes people repeat and insist that we don't see institutions specialized in labor and employment law. And as Professor Homero mentioned earlier today, it's a question of dialogue. Labor dispute resolution sometimes is a question of dialogue, and having a channel for labor peace, for industrial peace, and for labor dialogue, what's many times is really important for our countries. This is the chairman of the National Labor Relations Board. This is Mr. Ring, that I was honored to meet last month. It's his room. And there is, in the National Labor Relations Board, there is a general counsel that work as a labor prosecutor, and also commissioners, and this is the commissioner who is the chairman, and they work basically like judges deciding collective labor law cases. Equal Employment Opportunity Commission. Employment discrimination is a strong issue in the US, and the EEOC is the federal agency that administrates employment law in the US, and it's harder to watch hearings in the EEOC because they are secret, and there is a lot of private stuff and sometimes things about sexual harassment, gender orientation, sexual orientation, race, religion, this kind of issues. And it was interesting to visit. This is the EEOC in Washington, D.C. And as I told you, there are many different systems. I visited twice the MCAD, Massachusetts Commission Against Discrimination, where they deal with employment discrimination law, the employment discrimination statutes of Massachusetts. And they have 800 like free call phones that you can dial, and you can file a claim very easily at the MCAD. And I will skip this part. This is about minimum wages, and just compare each state has its own minimum wage, and they have the minimum wage is usually established per hour in the US, and here we usually have monthly minimum wages. Here in Brazil, for example, the federal minimum wage, and we follow basically the federal minimum wage, corresponds to 998 reais. And a regular worker working like 44 hours in a week would have a minimum wage of $1.13 per hour. And these are the state minimum wages in the US. For example, Massachusetts, the state minimum wage is $12, but now they have a strong campaign. It's called Fight for 15, in which they are trying to raise the national minimum wage, which is $7.25.
I have to finish.
Okay, I will be.
We are worried about the orchestra.
Okay, I would just to be very quickly.
It's a pity because it's so interesting.
So the last thing I will say is that the labor and employment law cases in the American Supreme Court are many. They receive about 80 cases, and they decide about 80 cases in one judiciary year, and many cases are decided in a 5-4 basis. And in 2016, when Justice Scalia passed away, it was the last year of the last President Obama's term, and Obama, in theory, he could appoint the 9th justice to the Supreme Court. But the Senate said, oh, we are not going to confirm, we are not going to vote at all, and so we are going to leave it to the next and to the following president. And so President Trump appointed Neil Gorsuch, and so many cases are being decided in a 5-4 basis. And just to finish, I like to quote Justice Ruth Bader Ginsburg, and there are movies about her, and I like Justice Ginsburg, and I like to mention that Justice Ginsburg, because the Supreme Court was becoming really conservative, and the American Supreme Court maybe has its more conservative composition since the 20s, like in 90 years, it's the most conservative composition of the American Supreme Court. And Justice Ginsburg was like becoming progressive and progressive. And Justice Scalia was the one who passed away in 2016. He was the most conservative justice in the American Supreme Court. And they discussed a lot during the sessions, but they were friends. They used to go to the opera together. And I think that right now here in Brazil and also in the US, we are facing a kind of bipartisan environment, and sometimes people fighting a lot with each other, and sometimes people even offending each other because of their ideologies. And Justice Ginsburg and Justice Scalia were on the opposite sides on labor and employment issues, but they were friends. And when Justice Scalia passed away, Justice Ginsburg was the one who provided the speech in his funeral. So I think we should learn with them and have more dialogue. And labor and employment law and labor courts, it's a question of dialogue and labor peace. So thank you very much. And I apologize again because it was an offhand speech.
Thank you, João. It was a pleasure to hear from you all this news from American legal system. Tomorrow at 9 a.m. we have the family law and environmental law. And now at 6 p.m. we have the São Paulo Orchestra in the first floor. For those who don't know where the Salão Nobre is, the first floor. Let's go there immediately. What? Oh, okay. There are some special chairs designated for us. Thank you. See you tomorrow. Thank you. João, seus pertences.
vou pegar aí. It was an honor.